Just a brief introduction of myself. I'm a lawyer at the Supreme Court based in Oslo. I have also, since the mid-90s, been working with a Democratic Progress Institute in London, which is an institute which primarily is involved in peace negotiations in countries which recently have had a high level of violence or civil war or genocide, and also administrating cases at the European Court of Human Rights. We have actually administrated more than 500 cases at the court, which I from now on will call the Court of Human Rights. This has given me an opportunity to follow the European development on the legal sector very close for the last 20 to 25 years. And today I would like to speak to you on some of the big changes in the governance of democracy which has taken place the last 25 and 30 years. These huge changes in the democratic society has been defined by changes in the law structure, changes in how the law has been introduced to the societies, and we call it legalization of the civil democratic society. It's also been called the judicialization of societies. As you probably are aware of, it is a big unrest at the time among the European communities. You're probably all aware of the Brexit, where UK now is leaving, or at least attempting to leave the European Union. We have a development in Hungary and in Poland, and certainly also quite recently in Italy, which starts showing somewhat hostility towards the common legal ground of Europe. And this has a dynamic which has been going on for about 25 years. It's been called a silent legal revolution, where the power, the political power of these civil modern democracies is shifting from the parliaments and to the courts. And this shift, this change of power or balancing of power, is closely linked to the problems we now can detect between the different European countries. So I will talk to you a little bit about what has happened the last 25 years, both at the national legislation and also at the international legal development. Then I will later talk to you about the rule of law as a concept and access to court as a dynamic under the concept of rule of law. Because the rule of law has a much more significant and important meaning today due to these huge changes in the way to govern the democracies in Europe based on this change of power. And then I will also speak to you a little bit about how rule of law can be used to fix the broken societies after periods of violence. And I will link this up to two quite famous examples of rule of law as a repairing mechanism after periods of grave violence and civil war, to the Iraq situation today, where we at this time are having a procedure towards the broken down IS or Daesh military groups. If we get time, I don't know, depends on the questions you have. You might, if you have questions, bring it on the table right away, or we can wait until the end of my speech. But if we have time, I will also try to talk to you about what has recently been very popular in Europe, a development called strategic litigation, where we use a topic, a specific legal topic, that we present a lot of cases to the courts to try to change the practice and also change the law by using international obligation as a tool. This new strategic development is now particularly of a high interest when it comes to the immigration and human rights law, and a recent and very new development called la verte révolution, which actually means the green revolution, and how civil society now are bringing pollution cases and the governing of pollution mechanisms in the society to the court to try to print down political responsibility instead of using the electoral elections as mechanism, trying to use the courts. And this is what is going on now in Europe, and the first cases are in court, and it is a developing and very interesting attempt to try to use the legal mechanism to clean up the societies. But we'll see how far I get. I have a time limit. I could keep on to 5 o'clock, but I know there's a lunch somewhere in between there, so I'll keep on as long as I can until I'm stopped. I told you that there is the role of national law in the modern democracies are now changing. It is from being an important part of a democracy, which is, of course, the law always have been. It's now changed to be the sole most important foundation of democracy. There is not possible to have a democratic society unless you have the rule of law as the foundation for the democracy. And this is a development which has been going on in the Western European, actually almost all of Europe, for approximately 25 years. It started when the international courts started to use the international conventions as a way of limiting the member states' democratic flexibility. And that was done because the international and national law changed from enable acts to right-based law. The difference between these two way of making law is that enabling acts is giving the authority to a ministry, from the parliament to a ministry, which of course is led by a political minister, giving them power of attorney to develop a system within the society. Because the ministries are politically controlled, they also kept the duties within the political framework. So that it wasn't a right-based law, but it was an enabling act, which is very, very difficult to bring to court, to kind of keep the ministers responsible for not fulfilling their individual needs. Then they started, about 25 years ago, to develop a new kind of law, and that was called right-based law. Instead of giving powers of attorney to the ministry, they legalized individual rights. That each individual should have the right for medical treatment within 2 months. Each elderly person has the right to live in a secure elderly home. That each child shall have so and so rights. And by changing this way of making laws, they also opened up for the courts, because as soon as you distribute rights to the individuals in a society, you open up for the court to control the rights. So every individual by that time started to use the court as a guarantee for the fulfillment of parliament legislation, which also drew the courts closer to the political process, and the court started to act within the political room of the society. At the same time as this change in the lawmaking procedures took place, we could also see an exponential growth of laws. It was an incredible growth in the lawmaking process, which means that the laws controlled a much wider space of the individuals in the society, as well as the lawmakers and the people in some public power position. And this exponential growth, together with the right-based law, made the room for the courts much, much wider than it had used to be. And it also became a conflict between the civil service and the courts, because the courts, in a much more tighter way, overthrew the civil service decisions, because their laws were then right-based, and that gave the courts the power. This kind of lawmaking also replaced ethical conducts within different work areas of the society. It put up official standards within all profession in the society, and it also made it very difficult to operate these so-called unofficial networks. And as everybody knows, the unofficial networks has been a very heavy and important parallel power in the democracy. It's been very powerful. But by replacing this law to right-based law, that became much more difficult to operate through so-called unofficial networks. The legalization meant also that it was more public and more transparent. It was easier to follow the decisions. It was easier to see that any decision distributing power or valids or equities that belong to the common society was done in a professional and clean way. So it became transparent, much more transparent the last 25 years, and much more public. And the role of the European Supreme Courts changed. And they have, the political powers are now trying to pen a word on them called legal activisms. And it's a debate, and it's also a conflict now between the political power and the Supreme Courts. But the question is that, or the way I see it at least, is that there is no legal activism at all. This is just a consequence of the right-based law, which brings all these cases with a clear political profile to it to the Supreme Court, and the Supreme Court has to make a standing. And this goes for the whole of Europe. This has been a tendency which you could follow out throughout the whole of Europe. And the Supreme Court is changing their positions and becoming more and more powerful. Enabling acts to right-based law means that you have access to court. That's the most important thing. You have access to court. If you mean that a decision is in an illegal way hurting your position in society, you can bring it to court. Whether it's a political decision or a political kind of, at least traditionally political field, you could still bring it to the court. The right-based acts, they define and protect your individual rights. It defines it because it is a legal definition, and it protects you because you can bring it to court and make sure that if the politician doesn't serve your interest in the correct way, you can bring it to the court and make the court make the decisions non-valid. And the court decision is binding for the civil service. They cannot cross or go opposite of the court decisions. It also activates the state responsibility, which means that if they make decisions which is not in accordance with your rights, you have a right to compensation. Because you could use the court to activate the political responsibility. But the big discussion as a consequence of this change is that it transfers power from the political mechanism to legal procedures. While you had very big difficulties fighting the state system, the ministries, the directorates, because it's very diffuse when it comes to power. It's difficult to change an ongoing practice in the state ministries or the directorates. Now you could shoot through that and go directly to court. And then the legal mechanisms will define your rights and overthrow any decisions which is not based on a proper conduct of law. The lawmaking process was, as I said, exponential. I've looked into Norway, the Norwegian statistics when it comes to the lawmaking process. In 1990, we had approximately 60 laws in Norway. There are, of course, many regulations and directives under the law, but the book of law was pretty small. It contained 60 laws which regulated the society. In 2004, we had 620 laws, quite a steep growth. And then 13 years later, 1,608 laws. So the book of law was just growing and growing and growing. The laws regulated the societies on a tighter and narrower base, and you have a lot of sector-related laws, as I call it, which only regulates tiny sectors of the society life. And by doing this, the legal provisions became the most important regulator in the modern political society, and not the politics. So we had a great change of power when it comes to the regulating mechanisms. The reason why we have this exponential growth in Europe at all is quite simple, but quite strange. And the main reason is that there is no more economy to discuss among the political parties. We got a change throughout these last 25 years from majority political governance to minority political party governance. Now the political landscape in Europe contains of a lot of small parties which have to sort of organize themselves in a minority government position. The economy in a country, like Norway, which has a very, because of the oil, of course, has a very big surplus in the economy, it is only manipulative for the political party between 3 and 5% of the BNP. The rest of the economy is locked down in long-term obligations, which cannot be changed from the party from one election to another. So the economy is usually in the most countries locked down in long obligatory agreements. Also international duties, of course, which means that there is the political discussions is not anymore so much about the economy. It is about values. And each minority or each political party has to define the difference between itself and the other parties. That is what politics is about. And since you cannot manifest any big difference on the economical spendage because the economy is more or less locked down, it's the values they use to present themselves as different from the other political parties. And values is law. To manifest a value, you create a law. And because the focus to prove your political identity is on values, it is legislation that happens. So every time we have a change of political positions in Norway and in other countries, there is a huge lawmaking procedure going on to make a footprint of your own politics for the future. And this dynamic is one of the main dynamics why we have gotten this huge growth of laws in the European society. And this extreme growth has consequences in the society. It leads to and encourage a more fair distribution of common equity. And that is because law is transparent. The state is more responsible because of that right-based law system, which means that it is more difficult to get away with unlawful conduct. And as you probably also know that in Europe it's becoming quite often criminal procedures against politicians, which was not very common earlier. In this country, 2 weeks ago, we had a very good example of that when the Prime Minister had to leave because of misspending of money belonging to the party. And this transparency and this responsibility, which is a result of this right-based law, the change in the law mechanism, leads to a more fair distribution of common equity. All laws institute application procedures. If you want to have a right, if you want to have some goods, if you want to have money, if you want to have right to a certain piece of land or whatever it is, it has to be an application procedure. It cannot be handed out through unofficial networks. That gives more certainty and a better control, better legal control of the distribution of common equity. It makes it more, predictability is better, and it's more foreseeable when you have application procedures, because you have to fulfill certain criteria to get a positive decision. And to do that, and these criteria are fixed in the law, which means that it's much more foreseeable whether or not you are entitled to certain rights in society as an individual. The role of the Supreme Court is becoming more and more important, and it's becoming, in some societies, a bigger and bigger problem. I don't know if you know about Poland. Poland is now in a huge conflict with EU because Poland got worried because of Supreme Court, which didn't actually do anything but decide upon the right-based law which had been developing in Poland, but it was not in favor of the state. So Poland instituted an election procedure where the politicians can choose the judges in the Supreme Court. And this is trying to stop the Supreme Court from following legal mechanism and get the Supreme Court more political. EU said no. There's no way that EU would accept Poland with such a principle of political control of the Supreme Courts. Poland called it legal activism. But what the Supreme Courts throughout Europe are doing now is civil protection. They are protecting the civil individuals and their rights which are given to them through the law. And of course, this means that there's a big shift of balance in the enacting power. The Supreme Courts are becoming more active on areas which used to be controlled by politics previously. And the Supreme Court uses the legal mechanisms and the rule of law, which I soon will come back to, as the most important mechanisms, and not political favors or anything else. But in some countries we can see that the burden often is placed on the courts, because the parliaments or the political parties in the parliaments are creating laws which to a certain degree is quite irresponsible laws, because it's a popular culture, and they create law to enhance a kind of a popular culture which is not often in good balance with the democratic institutions. And then they leave it to the court. And if it goes wrong, they say that it isn't our fault, it is the courts. So you can see somewhat as a political strategy to place the burden on the Supreme Courts. And some of these laws had been known or been found invalid by the Supreme Courts, because they are then hitting back again at the politicians, instituting bad laws, if you can use a common word, by declaring these laws for invalid. And they do now have the power to do that. So the Supreme Court is not only securing the rights, they are also actually involved in the legal creative procedures. They use dynamic models, they create new laws, they find invalid laws which doesn't follow a minimum of responsibility, and they have a larger room now for their activity than they've had ever before. But it's not only the national law which is changing. The international laws is also changing, and it's changing fast and with a very, very strong power. The international courts has in these 25 years developed what is called positive state obligations through interpretation of the conventions. Positive state obligations is actually obligations put on the state to do things. And that is quite different from saying to the state, don't breach this article in this convention, which is a negative state obligation. But now they are telling the state what to do. And that is a new development, and it's been developed specifically through the immigration cases at the Court of Human Rights and the EU Court of Justice. Because it has always been so that the state has the right to regulate who is to be on their territory and who is not to be. Who is to be given permits to stay or develop any kind of business on the state territory. Now the Court of Human Rights in several cases have said that people who have stayed illegally in a country of a member state, the member state has an obligation to give them a permit. They are, on the other hand, instructing the countries to issue permits or green cards for work or the right to establish businesses and other things, which means that it goes beyond what the international courts previously ever have done. And it has now become quite common. It was very controversial in the 1990s and 2000. Today, most states have accepted that the international courts and dispute mechanisms give them obligations to act within a certain framework, of course. They have also been given state responsibility through rather frequent judgment of compensation if they breach any of the articles. So the state is more and more facing responsibility through compensation to victims. Individual rights and application procedure has been a very high focus for the Court of Human Rights the last 10 years. That very often goes into the state procedure and say the state procedure lack fairness. Therefore, it is a breach of the convention. So they are not only busy with the material breaches, with the different articles in the human rights calendar, but they goes in and see whatever the result is, whether the result is correct or wrongful, the procedure is not fair, and therefore it's a breach of the conventions. They are developing positive legal definitions, which is developed within the courts, the international courts. Both the ICC in Hague and the EU courts and the Court of Human Rights and the UN Committee on Human Rights are developing their own definition of legal standards, which is rather new because they used to follow usually the legal definitions in the member states, but they've gone beyond that and have now more self-involved legal standards, which they demand that the member states follow. So the member states and the court at home has to change the national legal standards to harmonize it through the international legal standard. The courts are using interim measures, so-called Rule 39 or Rule 97 in the UN system, demanding the court, the member states, to stop procedures until they have finished treating your case. This is very typical in immigration or Article 3 procedures, where people are to be sent out, expelled, or expulsion procedures where the courts go in and say, stop, you're not allowed to send this individual out of our country before we have finished with the case. This is called interim measures. There was a very narrow scope for interim measures until 2000, 2003. And then both UN mechanisms and the EU mechanisms and also the Court of Human Rights started actively to use interim measures if they were worried that it could be a breach of the international standards. We also now have a development concerning commercial regulations, which are also being now a part of the international human rights catalogue. And we have specific instruments within the European the European Council, which has issued several protocols and conventions and agreement and directives concerning commercial regulations in the member states. Especially one which is quite becoming, which has been almost forgotten for 20 years, but is coming back now, the so-called European Convention on Establishments, which has specific regulations put upon the states to act and to put foreigners in a favorable position when it comes to establish business in the member states. And the special protections for foreigners which are working or are having business regulated in a member state. The international law has developed to individual protection. You have appeal rights in many conventions. It's a big theme at the moment with the Child Convention, a UN Child Convention, or the Convention on the Child's Rights. They're trying to establish a complaint mechanisms so that you can make individual complaints to UN under the Child Convention. Unfortunately, it comes 10 years too late. If this was proposed 10 years ago, it would probably be no problem. But now the European states are becoming afraid of all these international obligations, and they are very resilient at the moment when it comes to sign on to an individual right to bring applications concerning breaches of the convention. Another interesting aspect is what recently happened in the Court of Human Rights when they instituted for the first time the outside border responsibility. And the outside border responsibility is that if you, as an employed in a member state, breaches the human rights conventions in areas of the world where the European Convention on Human Rights is not operating, you are still responsible under the convention. To give an example, UK military were breaking the minimum standards in the Human Rights Convention when they were operated in Afghanistan. The Afghan individuals filed a complaint to the Court of Human Rights in Europe, and UK said, you cannot treat this case because Afghan is not an area which is regulated by the Court of Human Rights or the Convention on Human Rights, European Convention on Human Rights. And the court just recently said it doesn't matter. As a UK citizen employed as a representative and employed by the UK state, you are still responsible wherever you are in the world. This is a highly controversial point of view from the court, but still it is developing, which means that the Court of Human Rights Convention could have the whole world as an operatum modus, if this is in the end the result. It has to go to the Grand Chamber, and there still is a lot of legal work, but it's opening up for out-of-border responsibility. So the geographical scope of the convention is getting wider and wider. When it comes to the international treaties, we do at the moment have an enormous amount of convention and treaties operating in the different states. I've been talking to the Norwegian Minister of Justice, and I can say that they are not really sure how many conventions and treaties. It seems like there's been so many now that they don't really have a full understanding, because it's been 30 years of positivism. Norway have signed any kind of treaty that they came across and say, hey, we are so good. And at the moment, we have more or less lost control. And I think I know that UK was not aware of how many directives from the EU they had signed before they were going to start the Brexit negotiations. And at the moment, they are trying to find out how many treaties and directives they actually are bound by. So it's been 30 years with an enormous growth of treaties. In there are 560 multilateral treaties effective today. 560 treaties. The European Council has 140 multilateral treaties operating, among them the human rights conventions and protocols and so on. There are numerous bilateral and regional treaties. Just before I left, I tried to check with the Ministry of Foreign Affairs in Norway how many directives Norway have been signed on to. And we are not there because we're not an EU member, so we are not there actually to negotiate these. We just have to accept them because they come from EU through our EEC treaty with the EU. The number, as far as they were able to find out, is 11,013 directives is regulating the Norwegian society. More than 11,000 directives. And beside all these international lawmaking procedures, it is also the standards which are being developed by the court, specifically the European Court of Human Rights, which are regulating the legal space in the European countries. I don't know if you can see this, its writing is probably too small, but I will go through the numbers just to indicate what an enormous amount of standards which has been then a consequence of the decisions by the Court of Human Rights. Last year, 63,500 applications came to the court. 63,000 applications. That was a growth of 19% from the year before. They decided on 85,951 applications was decided on by the Court of Human Rights. 85,000 cases. By judgments, last year the court ruled and decided with a judgment 15,500, almost 15,600 cases. 15,000 judgments was made in 1 year. That was a growth of over 700%, so it was a very, very busy year in the courts last year in 2017. But all these standards that comes out of all these judgments are binding for the national politicians. And the backlog at the moment is about 56,000 cases in the Court of Human Rights at the end of 2017. Interim measures were granted in 117 cases. Interim measures is where the court goes in and says, stop, you're not allowed to continue with whatever you're doing until we have finished treating your case. So it's a direct interference in the procedure in the national different member states. So in 117 cases, the court went in and asked the state to stop whatever proceedings they were doing. And a court case in the Court of Human Rights will take approximately, at the moment, between 18 and 24 months. So it's a long break before they are able to decide. When it comes to the country-by-country cases, it shows that the best guys in the classroom is Andorra and Liechtenstein. It's not very strange because they're very small. They only had one case each, so it's not very strange. Romania at the moment has 9,920 cases pending in the system of the Court of Human Rights, and the Russian Federation 7,747 cases, and Ukraine 7,112 cases. So it's from the backlog of the member states, Romania, Russia, and Ukraine together has quite a lot of the cases in the Court of Human Rights. But of course, this enormous law establishing standards that comes out of the Court of Human Rights comes on top of an enormous load of international treaties, which often are right-based, which comes on top of an enormous growth of national law in the different European communities. And if you put all these together, and all these are manageable areas for the Supreme Court, it shows you that the Supreme Court of Europe now is handling quite a lot of the control mechanisms that used to be regulated by politicians are now regulated by legal mechanisms in the different member states. And that is why we have a much more legalized system now for the last 20 years than we've ever had. And the core part of the court is becoming bigger and bigger. On the national level, is a conclusion, you can say that there's been a power shift from the governments to the Supreme Court. the international law limits the democratic flexibility quite a lot. It's not easy to pass a law in the parliament now without hitting the boundaries of an international standards. So the flexibility, the democratic political room to move in is becoming more and more narrow. This is the big problem behind the Brexit, together with the immigration problems which they are dealing with. Also, the problems coming out of Hungary, Italy at the moment, and Greece is linked to this narrowing down on the democratic freedom, because of this amount of legal regulations which comes out of the system. But on the other hand, it guarantees a better stability, judiciary procedures, and better safeguards for civil and individual rights. And the access to court is a protective measure which is securing the individual rights, which is governed by the laws. And it also now in Europe, there is a big international harmonization of the rule of law. But there are some challenges. There are some important challenges coming up. And one is linked to the immigration law. It's international regulation versus state sovereignty. This is a complex, it's very aggressive and difficult to solve. And it's a big challenge within EU to get a common grip on. And the other one, which is now coming up as a big challenge in the legal and political sector in Europe, is the Nouvelle Révolution Verte, the new revolution on the green, relating to the green laws, as they are saying. Today, there is 90 constitutions, 90 countries which have in their constitution guaranteed the right to a healthy environment. The problem is that the same 90 countries also pollute. I mean they have the right to pollute, as same as they go into the constitutions, that they have the duty to see that the environment is being protected. This has always been mainly a political area of international negotiations. The legal societies in Europe, there are groups now trying to make this into a legal question. France have recently brought a huge case to the courts for the politician to get a conviction that the politicians are not doing enough for the environment to create a healthy society for the individuals. Norway has one huge case running on into the different levels of the court system. Germany is just 2 weeks ago filed a huge indictment against the state for the same thing, and there is a huge movement in Europe trying to bring these issues into a legal context under the court, which they will, in a way, probably be able to do, but it's very difficult to say anything about the outcome. But these two movements at the time could be said to be some of the most important challenges that we will face in the coming years. We'll just end with a short speech on the rule of law, because as this development has come along for 25 years, the concept of rule of law becomes more and more important in the governance of the democratic society. It is, in Europe we had originally three systems of rule of law. We had the common law rule of law, we have the civil law, the German perspective, which is called Rechtssicherheit. It's a bit different from the rule of law. We'll talk more about the rule of law, but the German concept, is more linked to the mechanism. To create mechanisms that in the end will lead to a correct results. So its Rechtssicherheit is more linked to the organizing of the courts, while rule of law is a bit different on that way. And then we have the French and partly Turkish model, which is equality, legality, and freedom. The three slogans brought out from the French Revolution many years ago. But the rule of law, which is the more and more commonly used methods of measuring the stability and security in the society, is divided into three quite simple factors. It's rule according to law, it's rule under law, and the more diffuse and difficult aspect, rule according to higher law. These are the three elements of the concept of rule of law. And these three elements is definitely the foundation for a democratic society today. Rule according to law can be easily defined. The government is required to exercise its power in accordance with well-established and clearly written rules, regulations, and principles. There are two important words in this first group of the rule of law concept, and that is well-established and clearly written. Both these two wordings is extremely important. We just had a very interesting case against Italy in the Court of Human Rights, the Tomasi Case, where a person, the Tomasi, he was clearly not a nice guy, to say the least. He had been involved in quite a lot of criminality during the years, but he'd served his sentence and he was put under police surveillance after he served his sentence. And the base for this police surveillance was that he was associating with other criminals, that he was not living a law-abiding life. These regulations were then brought into the Court of Human Rights, and the Court of Human Rights just decided that this is not clearly written rules. Having criminal friends and not living a law-abiding life is not a legal standard. And it's difficult for an individual to know how to relate to such a vague descriptions. So they found that these police surveillance was in breach of Article 8 of the Convention of Respect for Private Life. So the concept of clearly written laws is extremely valid in the rule of law. Rule under law is the government must exercise its power under the law. No one is above the law. Which is, and to say from a Norwegian perspective, not always correct. Because we have a king. And sort of kind of a fairy tale government in Norway. But we have a king, and the king is above the law. So it's not in all cases the facts, but it is reserved for the kingdoms only, and it's only the sovereign. It's not his family members, of course. It used to be his family members too, but not anymore. So, except from this exception, it's rule under law that everybody is to be tried under law. Rule according to a higher law is a concept which came out of the Second World War, because it was an argument used by the indicted war criminals at the Nuremberg case. They said, but we were only following the law, which was correct. Under Hitler, the law, the crimes against humanity that they were involved in was in accordance with German law. And that's why they said, that is not an acceptable legal argument, because the law must be unwritten principle of equality, autonomy, dignity, and respect have to transcend ordinary written laws that are enacted by the government. It's called the higher law theory. It has also been said that other legal theories assert that all written laws must conform with universal principle of morality, fairness, and justice. It's more or less the same thing. So it's not enough that your acts are in accordance with the law. This law has to be fair and based on humanitarian and human principles. And it is always a minimum standard. So the legal certainty, the rule of law, three important things here that gives legal certainty. It's defining your position as an individual in a democratic society. It's foreseeability, you can make the right decision, you know your consequences of your decisions, and it's equality before the law. So it protects your position. And that's the fundamentals of rule of law, which have now become the fundament of the modern democracy.